Good morning, everyone. So my name is Bogdan Miščević, and I'm an associate lawyer here at Dentons. My practice is about 50% insurance litigation, and the other 50% is commercial litigation. So obviously my CV is nowhere as impressive as Norm's. But interesting thing about me, prior to law school, I actually worked as an insurance claims adjuster over at Wawanesa Mutual. So to start off, we don't have the PowerPoints up, but obviously we're talking about pretrial injunctive relief. And when you're talking about pretrial injunctive relief, first thing you got to look at are those ex parte injunctions. And where do you start off? You start off with the Courts of Justice Act, and you start off at Section 101. So I'm just going to read a Section 101 to you. In the Superior Court of Justice, an interlocutory injunction or mandatory order may be granted where it appears to a judge of the court to be just and convenient to do so. So you hear that language, that's a very broad language. So just like any statute, you would start off with a very broad language, and then through the rules of civil procedure and case law, you start eventually narrowing it down. The leading case that you would have to look at if you're talking about ex parte injunctions is probably R Mcdonald V Canada. So this is a 1994 Supreme Court of Canada decision. And the facts are kind of interesting. It was two applicants. They were both tobacco companies from Canada, and they sought a stay in form of an interlocutory relief from compliance of something called a Tobacco Products Control Regulation, which was regulating the tobacco products and health warnings. So if you look at cigarette packs today, you would have 75% has to be covered by a warning, some sort of a health warning, and then at the bottom you would have 25% saying what the label is, whether it's Belmont, Du Maurier, whatnot. Back then, it was a 25% warning, and 75% will be essentially an advertisement for the tobacco. So in July 1991, Quebec Superior Court actually held in favor of the applicants, held that they don't have to put those health warnings for a certain period after the regulation is passed. Obviously, it was appealed by the Attorney General, and then the appeal was held in favor of the tobacco companies, and that's how this case made it to the Supreme Court, because they kept pushing it up. So they calculated that it would cost them, the applicants, the tobacco companies, that it would, to redesign their labels and to accommodate all these warnings, it would be approximately $30 million. It would cost them. So obviously this is $30 million in 1994 Canadian dollars, so very significant money. So you can tell that's the reason why it went all the way to Supreme Court, because it was very important to them. And this is why it went all the way up. So, but the important part about this Supreme Court decision is the test that was established. So this is why the case is important. And the test is very basic. It's a 1994 test. The basic test to meet by an applicant requesting interlocutory relief requires an applicant to establish the following, and it's a three-pronged test. First, there is a serious issue to be tried. Second, the balance of convenience favors granting injunction. And third, irreparable harm would be occasioned in the event injunction isn't granted, in a sense that damages would not be an adequate remedy. So Supreme Court applied the facts of the case to this three-pronged test. When it came to the first part, they said, yeah, there is a serious question here. So that prong was met. They looked at the irreparable harm and they said, well, there's a financial loss here. It's $30 million. They held that it was irreparable harm. Because this is 1994, my guess is today, they would have a harder time arguing the financial loss is irreparable harm, whereas back then they actually held that. And the last one is that couldn't be met was the balance of inconvenience, which the Supreme Court held that it weighed in favor of the Attorney General. And how did they hold this? Well, sure, you had the $30 million on one hand, but you got to look at the applicants themselves. These are tobacco companies. Their annual earnings were over $50 million, so they definitely had the capacity to absorb the financial loss. And even if they couldn't, they could pass that on. The Supreme Court even said they could pass it on to their consumers by increasing the prices of those tobacco products. So as a result, the public interest carried a greater weight in this decision. The new regulations were intended to protect the public health and further public good. So therefore, the applicant's request for stay failed the three-part test that I outlined earlier. So this is a really good case to look at for an explanation and for reasoning, and actually a really good analysis when it comes to the three-prong test. So next thing that I want to briefly talk about is something called a preservation of rights in pending litigation. When you're talking about preservation of rights in pending litigation, you have to look at Rule 40 of the Rules of Civil Procedure. And this deals with interlocutory injunctions and mandatory orders. So this rule, Rule 40, supplements the two sections of the Courts of Justice Act. So remember how I said earlier when I read out the Section 101, it was very broad. Now we're getting into the Rules of Civil Procedure where it starts narrowing and actually really explaining what those sections mean. So if you look at Rule 40.01, it states as following. An interlocutory injunction or mandatory order under Section 101 of the Courts of Justice Act may be obtained on a motion to a judge by a party to a pending or intended proceeding. So this is where the law starts getting more tailored, like I said, going from the Courts of Justice Act now into the Rules of Civil Procedure and really explaining what those things mean. So the second part that's explained is, well, maximum duration. How long can you take these injunctions out for, especially if they're on an ex parte basis? So Rule 40.02 says, interlocutory injunction or mandatory order may be granted a motion without notice for a period not exceeding 10 days. So if you're looking to do it for a longer period than that, then the motion cannot be done on a without notice basis. But there is a way the rules allow for and an extension where an interlocutory injunction or mandatory order is granted. So once you get it on an ex parte basis, your next step is to extend that ex parte basis. But at that point, you can only do it if you're actually giving a notice to every party that's affected. Unless, and then they gave two exceptions. One of them is the other party is avoiding service. But this kind of makes sense, this language. Otherwise, you would just have a party do an ex parte, 10 days, and then keep extending it on an ex parte basis, and that just wouldn't be fair. So this time you get to do it first time, but then after 10 days, you have to do it in an order. And you have to do it on notice to all the other parties. It also makes sense, when I was talking about those exceptions, because if the other party is avoiding service, they shouldn't be awarded for that. So there is an exception. You don't have to do it on notice if you can establish that they were evading service. So if the injunction was initially made on without notice basis, now you can do it. Now you have to do it on notice, unless you can meet one of the two exceptions. One is, like I said, evading service, and the other one is exceptional circumstances. And usually courts leave this if you have exceptional circumstances that you can explain in front of a judge. So an interesting side note is, and obviously for those of you that practice commercial litigation on a regular basis, you know this, but for those of you that don't, well, what would happen is if you want to ask for an injunction before that statement of claim or notice of action has been issued, how do you deal with it? Because think about it, there's no court file number yet. So how they deal with it, the courts will assign a provisional temporary number to the injunction. They'll deal with it on those bases, and once you have that statement of claim, that notice of action, then they'll just add it to those. So what are some of the reasons for moving on an ex parte basis? Moving on an ex parte does not provide the respondents with any ability to defeat the point of the motion. So think about it, the responding party is not even there. Put differently, an unnoticed motion would tip off the respondent, rendering the motion moot, or at the very least less effective because they'll get to challenge it. Some of the evidence that you can bring on these ex parte motions are affidavits in support and undertaking in damages. So if you look at Rule 40.3, they deal with that, with kind of explaining what's the kind of the evidence you get to bring. The affiant will eventually be cross-examined on the subsequent motion to extend that ex parte motion. So you got to be careful. When you first submit your motion materials, you're going to have your affidavit in there. That affidavit needs to be airtight, because what's going to happen is once you're extending that injunction later on, you got to make the other party, responding party, is going to be there, and then they're going to really scrutinize your affidavits. You got to make sure it's airtight from the beginning. Obviously, the affiant in the motion to extend an ex parte will usually file their fresh affidavit in support of the motion. They're also going to be making references to that original affidavit. And this is obviously why you see that the initial affidavit is important, because now it will essentially be under a microscope by the opposing party. So any vagueness, any sort of misleading evidence, anything you can find in that first one, although you might get away with it because the responding party is not there in that first motion, once you're extending it, then at that point they're gonna scrutinize it because the responding party is gonna be there. So some of the pros and cons of moving on an ex parte basis. So why should you even move on an ex parte basis, and why it might not sometimes be a good idea? An ex parte junction, like I said, is only valid for 10 days. So then it needs to be extended on consent or by court order. So when you're extending it, your affidavit, like I said, is going to be under scrutiny by the responding side. The ex parte injunction, once issued, is required to be served on the responding party the day the ex parte injunction is issued. So obviously the timelines are tight. This is something you got to consider if you're moving forward with an ex parte injunction. From a practical point of view, and I'm sure Norm will agree, ex parte injunctions are often extended on consent without prejudice basis. So it works to the responding party's advantage if they can live with the injunction, at least if they can live with the status quo for the time being, they'll agree to extend it on consent, and then they'll have enough time to prepare their own responding materials, their own affidavit, their own factum, and really challenge the other side. Not just that, they can prepare obviously cross-examinations and stuff like that. But what are some of the special considerations when moving on an ex parte basis? There is a heightened need, especially in these ex parte motions, for counsel to disclose all relevant facts. So I'm sure obviously if you're ever in front of a judge in court or in front of even an adjudicator in a private administrative tribunal, obviously you want to reveal all the facts. But there's a heightened need, and I stress the word heightened, when you're talking about ex parte motion. Why? Because, well, the responding party is not there. And a lot of the times the judges themselves don't have the time to review 3 binders of the submission, so you really have to bring it to their attention about certain sections, even if they're not helpful to your case. So a failure to do so could actually have grave consequences. Failure to reveal a material fact that might not be helpful to you, but might be helpful to the responding side. And a really good example is it's a 2014 Ontario Court of Appeal decision. It's an Ontario decision, United States of America v. Yamak. And this essentially dealt with an ex parte injunction where Justice Nordheimer ended up allowing it because the responding party wasn't there to challenge it, and then Justice Gans actually found out that there was a material, there was a non-disclosure of a material facts. So what ended up doing, this really blew up because it went to the Court of Appeal, and there was even a 15-day damages hearing, which eventually led to almost $1 million in damages to the responding side. So this is because the reasoning, I guess the public policy reasons behind it is, with great power comes a great responsibility. When you're up there and you're kind of on an ex parte basis, the responding party is not there to challenge anything, the judge hasn't really got a chance to review everything, it's really your responsibility to bring certain facts that might not be pleasable to you to the judge's attention. So you can't just bury it in Exhibit D, page 300, and say, well, look, I've disclosed it there. No, you should be bringing it to the judge's attention. So Justice Gans in this case, and I'm going to read this out to you because, again, I think this is important, said as follows. Ex parte injunctions present judges with the most vexing of issues on an immediate and urgent basis, while simultaneously obliging the moving party to make full and frank disclosure of the relevant facts. And that full and frank disclosure later on comes really important. Justice Gans also then went out to acknowledge, essentially pointed out well-known principles obliging a plaintiff on an ex parte application to make full and frank disclosure. So what Justice Gans said gave essentially a list of what is considered a non-full frank disclosure. And some of the examples are, one of them I already said, non-disclosure of material facts in support of the defendant's position, misstatement of the then current state of law and state of affairs in law. So that's let's say in your factum, you haven't stated some of the law that's maybe unfavorable to you, but would have been really favorable to the responding side. Another one is overstatement of the position in support of the moving party. Selective exclusion of relevant information. I see this as more as it's cherry picking. You're picking all the facts that are favorable to you, you're putting it in front of the judge, but you're not really raising the judge's attention to some of the favorable facts that might have been favorable to the responding party. And another one that Justice Gans said was extensive use of exhibits without detailed reference to relevant material in the body of affidavit. So that is, you're essentially having a bunch of these exhibits that are 300-400 pages, but you're not making particular references to certain sections. So Justice Gans said the following: no judge entertaining an ex parte motion could be expected to read, assimilate, and understand all or even a majority of the material thrust before him or her, even if the task were limited to affidavits. So that's essentially saying what I just said. So it's a burden on the moving party to explain, dissect, and help the court when they're bringing these ex parte injunctions. So as such, it remains an open that merely burying these facts in documentation is not enough. So based on that language of Justice Gans, you can't just bury something in the documentation. You also, if it's something is material, you would have to bring it to the judge's attention. As you cannot expect a judge to review all of the materials, especially if the materials are large. So as such, the party that moved an ex parte basis, if they don't bring this, they will be punished, especially in the form of damages later on. Justice Gans determined inevitably that this was an injustice would be undone if this injunction were continued. It wasn't allowed, and then as consequences, they actually had a cost hearing. And this cost hearing was for 15 days, and this is where the responding party was actually given, granted, I think it was $954,000. And in order to justify this granting, Justice Gans said the following, and I'm going to read this quotation. In my view, an award of costs at this stage of the proceedings, in circumstances where I found an injunction was obtained without full and frank disclosure, warrants, if not mandates, not only redress of the costs incurred by the defendant so affected, but a sanction meted out by the court against those who have trifled with, if not torn asunder, the very essence of integrity of ex parte process. So those are very powerful words. Thank God I'm not speaking here from experience, but you really don't want to be on the receiving end of a decision like that. Subsequently, the court ordered that the plaintiffs pay $954,000 to the responding party. So in other words, you better adhere to these disclosure requirements. You better have all your ducks in a row before moving on an ex parte basis, because it could cost you greatly, especially in a decision like this. Next thing that I wanted to talk about is a sealing order or protective order. So is a sealing order or protective order necessary when an ex parte injunction is being brought? And one good decision that kind of speaks to that, it's also a Supreme Court decision from 2002, Sierra Club v. Canada. So this was very briefly the facts. I'm not going to bore you too much with the facts of this case, but very briefly, it's Sierra Club was an environmental organization. They were seeking a judicial review of the federal government's decision to provide financial assistance to something called Atomic Energy of Canada, which was a crown corporation that was selling reactors in People's Republic of China. So what happened there? The reason why this case is important is because it outlined the test for confidentiality orders and when they should be granted. So the test is as follows. It's a two-prong test, but the first prong is eventually broken down into three more prongs. So the first prong is, so a confidentiality order should only be granted when such an order is necessary to prevent a serious risk to an important interest. And then you break this down. Well, what is meant by serious risk? The risk must be real and substantial. The important commercial interest must be one which can be expressed in terms of a public interest in confidentiality. The judge is required to consider or not not only whether reasonable alternatives are available to such an order, but also to restrict the order as much as it is reasonably possible. That's our first prong. The second prong is the salutary effects of the confidentiality order outweigh its deleterious effects. So eventually there's weighing there. So whoever here regularly practices commercial litigation and they're regularly, let's say, in the commercial list in Toronto, would have noticed in the past couple of years that the judges, especially in Toronto and especially in commercial list, are now requiring parties to establish that Sierra Club test for granting sealing orders has been made out. And I think there were some decisions, I think it was Justice Dunphy that stated in Rumson Investment Corporation that Sierra Club is now essentially the law of the land. So you have to establish it. So when you're submitting your factum and you're making any other documentations, especially to the commercial list in Toronto, you must ensure that you're making references to Sierra Club, and you must ensure that you're satisfying that test that I listed earlier. Justice Farley in Stelco Incorporated said it stressed the importance of an open court system. And as such, you have this weighing constantly that's going on in these types of proceedings. On one hand, you have the confidentiality and the need for it, and then you have that weighed against the adherence of an open court system. So in other words, it's not just to the parties, to the proceeding, because there's a larger public interest at play here. So let's talk about extending an ex parte injunction until trial. So remember, if it's not on notice, you can only do it up to 10 days maximum, and then you have to extend it with on notice to the responding party. So some of the timing, procedure, and evidence. Some of the evidence that can be used in this motion, so once you're extending, at this point you have the responding party there, is outlined in Rule 39.03. Some of it is examinations. So you're essentially going to have a witness examined, similar to examination for discovery. You're going to have a transcript. You're going to have a court reporter there. You can enter exhibits, stuff like that. Other evidence is cross-examination and re-examination. So those are, that same witness is being cross-examined and re-examined on that affidavit. And something important to stress in this particular section is it has to be exercised with reasonable diligence. So you can't just book a motion to extend and then ask for an adjournment later on because you didn't get a chance to do your examination, re-examination, cross-examination. Because Rule 39 actually says to be exercised with reasonable diligence, the court may refuse an adjournment of a motion for the purposes of an examination. So what's that essentially saying is get all your ducks in a row before you do this motion. Don't just book it and then later ask for an adjournment because you can't get your examination in place. Some of the other evidence you get to bring is obviously affidavits in support, affidavits responding, that's what the responding party is going to bring. You're going to have your cross-examinations and affidavits, and probably the most important one is your oral evidence in front of the judge. Some of the moving party strategies. So remember, the moving party, if you're a moving party, you're trying to convince the judge that nothing has changed since you filed that ex parte injunction earlier. When you're on ex parte basis there, the responding party wasn't there. You want to say nothing has changed and we should just continue proceeding to extend this until trial, perhaps. So what you need to do is the respondent's position has not changed anything. There remains a serious issue to be tried. The balance and convenience still favors the moving party, and damages would not be an adequate remedy. So when you're drafting your written materials, when you're preparing your oral arguments, you constantly need to tie them back to this three-prong test when you're a moving party. So similarly, if you're a responding party, what you need to do is you essentially need to argue everything opposite. So an ex parte injunction should not be granted in the first place. Remember, responding party is probably not happy that they were never invited to first place because it was not on notice. They should say it shouldn't have even been granted in the first place. In the alternative, they would argue, even if it was granted properly, there's no need to extend it further, especially not until trial. So there's no basis for continuing an ex parte injunction until trial. They're going to argue there's no serious issue to be tried. the balance of convenience favors the respondents, damages would not be an adequate remedy. So just like the moving party, the responding party's written documentation, their oral advocacy is constantly going to be tied back to these three prongs. And unlike the moving party, the responding party now will actually be able to attack that original affidavit from that original ex parte motion. So I think this kind of concludes my part of the presentation, but what I'm going to do now, I'm going to pass it to Norm, who's going to talk to us about defending a motion to set aside an ex parte injunction.
So I'm going to hop in and deal with the professionalism component of this presentation. And the conundrum that a lawyer or lawyers are in when they have a client that says, I've got to go to court on an ex parte basis, is you want to get the judge as fast as possible. Oftentimes the judge is got a full list. This could be taking place on a Friday afternoon, and there's a premium put on assembling your material, but only the material that you need in order to get the ex parte injunction. If your client has given you a data dump of material and you're not certain as to whether or not it is of any moment, you cannot simply bundle it all up and send it off to the court expecting to be able to say, well, the court had it. I've had injunctions where I spend 30 seconds with the judge, and then I'm called in an hour later and I have an endorsement. And there's no back and forth between the judge and myself in that case, asking me questions about what about this, what about that. There also is likely not to be a court reporter. So in cases where you do spend some time with the judge and the judge is actually asking you difficult questions about, well, what would the other side say if they were here? And you've got to be able to answer those things. If there's no court reporter taking a transcript of that toing and froing between the judge, you should, out of prudence, when you get back to the office, hopefully with your ex parte order, do a memo to file and memorialize the length of time you spent before the judge, the nature of the questions were asked, the material that you took the judge to, so that later on, once the motion record has been served with the order that's been issued, if the responding party lawyers up and then brings a motion to set aside on the basis that the judge was in effect hoodwinked in granting the ex parte order, you'll be able to go back to the file and say, no, we spent 15 minutes on this issue, we spent 5 minutes on this issue, but that motion to set aside may be coming on about a year down the road. If you're lucky enough or fortunate enough to get your case on the commercial list, and we'll talk about how to do that in a moment, you're likely to have the motion to extend brought on before the judge that granted the initial order. And judges are not going to be too quick to say to somebody that they know, oh yes, you know, I was hoodwinked by so-and-so who I've known for many, many years. So when you get the responding material delivered in response to your motion to extend, it's not always the case that they also move to set aside the initial ex parte order. It's a bit of a slap in the face, and it's an aggressive strategy, but it's often used to sort of put the fear of God in the moving party and the moving party's lawyer that somehow you got this order without making true, full, and fair disclosure. So at the point in time when your client comes in and you say, we have an ironclad case, we got to go to court really fast, the lawyer, who's got a duty to the court and a duty to the client and also wants to get a good result, has to spend some time critically asking the client questions of the sort that the client's going to be asked by the other side once the on-notice motion to extend is brought. You know, you may not be able to fully develop all of your arguments in support of why this injunction should be extended, but you certainly don't want to be in a situation on the motion to extend and or the motion to set aside that you've misstated some facts either to the judge or your affiant has misstated something or overstated something. And this undertaking in damages that a moving party has to give is sort of a stock phrase that you basically cut and paste and put in an affidavit that's, you know, the company that I work for will abide by any order that the court makes if it turns out that the injunction should not have been granted. It's not every case where the motion to set aside is coupled by a request by the party that set it aside for a damages hearing. In the extreme case that Bogdan talked about is the responding party was able to establish after a 15-day damages hearing damages short of $1 million, which had been occasioned to it by reason of the fact that their assets were frozen. So some ex-party motions, some motions brought without notice are always going to be without notice. Mareva injunctions to freeze bank accounts. Anton pillar orders, a civil search warrant. The responding party obviously learns about the issuance of the order the day it's granted. And they're, in a case of Mareva, usually allowed to take out money for living expenses, and different people have different levels of living expenses, and also lawyers' fees. Now, what typically happens in those cases is that there's a negotiation. If you have a case that's actually started, it's civil action for X million dollars in damages, and you advise the court, we want the assets of the defendant or defendants frozen to the extent of what we're claiming. That's sort of like mile high, apple pie. But when you get into the case, it may be that you've overstated the amount of money that you're actually claiming. And you go back to court, and typically a respondent will say, well, you can't freeze my assets up to the amount that you've claimed for. There's no evidence of that. And sometimes there's a negotiation to freeze an extent of assets and not even have the motion to extend fought out. You've got the parties agreeing on a without prejudice basis, I will agree that Mareva injunction could sit in place and I'm not going to touch X $100,000. I'm able to use any excess assets over that, and if we have to go back to court, we will go back to court. That becomes an attractive proposition to the party that's obtained the Mareva injunction, because they don't have to concern themselves with educating the court to extend it. It's extended on consent. And they don't have to concern themselves with a motion to set aside the initial order on the basis that they somehow hoodwinked the court. The whole issue about living expenses and what's reasonable and legal expenses is what's reasonable is an interesting issue, because the lawyers for the moving party are spending a lot of time and money and charging their client a lot of fees. And when the other side says the respondents need this amount of money to pay our legal fees, you're not going to find too many lawyers on for the moving party that's going to say you're asking for too much by way of legal fees. The practical reality is, with the 10-day comeback period, is you're never back in court 10 days after you get the ex-party order. It gets served. The party typically will take some time to lawyer up. The lawyer for the respondent only ends up with the actual order that's been served, but they're going to ask for what was the material that you placed before the judge. And if you say, well, we had a factum and we had a motion record and we had 4 volumes of case law, they will then ask, and did you take the judge to this passage in the case at tab 28, which might not be favorable to your case. So again, be careful of overburdening the court with material that you have no intention of referring to, because it just becomes grist for the mill for respondents' counsel to say, well, you've packaged this thing up in a factum to look very pretty, but in effect there's some problems with your case that you didn't draw to the attention of the court. That's not necessarily going to tip the scales in terms of setting aside the ex parte, but why set yourself up for something that you can do away with if you have, one critical case like R Mcdonald, critical facts, and leave some room in the affidavit to add to the affidavit. If your affiant says, these are the facts, as of today, and we're in the process of investigating something further, you've got some wiggle room to add in. Most of the time when you're retained to bring these motions, it's like in white heat. Your client says, we've got to go to court. All hell's going to break loose if we don't get a judge. So practically speaking, in Toronto, you want to get onto the commercial list. Not all cases meet the commercial list criteria, but thankfully there's a basket clause at the end of the paragraph that says something to the effect that any other case that a commercial list judge considers should be heard by the commercial list judge. And there are cases that you can get onto the commercial list without even having to make any kind of a pitch that it meets the condition of the basket clause. The beauty of the commercial list in Toronto is it's a small cadre of maybe 4 or 5 judges. They deal with injunctions probably more than the regular list judges do. The regular list judges don't necessarily get seized of a matter. So if a regular list judge issues an injunction, the motion to set aside may or may not come back before that same judge. In the commercial list, the practice direction is once a commercial list judge hears anything of any substance, that same judge hears every motion. So if you can get yourself before a judge who isn't saddled with a lengthy trial, the motion to extend will be before that judge. The motion to set aside, if it's brought on, will be before that judge. And you don't have to re-educate that judge on what happened during the course of the initial ex parte motion. But it does require you, because you're putting together material in a very short period of time, to ask your client or clients difficult questions and put yourself in the judge's position. Not all judges will do this. Some judges will say, "Oh, nice to see you, Mr. Emblem. Isn't it cold out today? And do you have a draft order for me?" But you've got to take the time to, whether the judge has the time or not, to hit the high points of your case, lest you're going to be accused of running it through without alerting the judge to the possible problems with the case. The issue that Bogdan talked about in terms of sealing orders and protective orders is an important one, because if you're in court on an ex parte basis, not on a Mareva to freeze assets, not on an Anton Pillar for search warrant, but to enjoin or prevent a party from doing something, publishing something, writing something, disseminating something, you've got to put material before the court to demonstrate that there's a threat of some activity such that giving notice to the respondent would render moot the entire point of the ex parte motion. So the category of ex parte motions other than Marevas and Anton Pillars, where you have to say, this is the reason we're not giving notice. You just can't mail that in. You've got to have some evidence. You've got to have some material before the court to demonstrate to the court that this is a case where notice should not be given. And there is no discretion on the ex parte to extend it past 10 days. I had a case several years ago where we were in court right before Christmas, and the 10 days ended on like January the 2nd. And I had wanted it to be returnable on the 6th. And the only thing that was changed in my draft order was the judge stroking out 6 and putting 2. So it ended up being adjourned on consent because there's very little likelihood of somebody being able to lawyer up, get all of their material ready within 10 days or the first return date after 10 days. So the initial fight, you get your order, but then the real fighting begins. And as a practical matter, and Ontario is a bit different than some other provinces. Ontario, you can bring a motion before an action started. And if you don't have time to draft a notice of action or statement of claim, you're basically going to court without the benefit of having a well-developed, articulated pleading for the judge to be able to say, yes, there is a serious issue to be tried. In other provinces, you actually have to issue a claim, whether it's a notice of civil action in BC or the equivalent of a statement of claim somewhere else. So that's a bit more of a hurdle, more material for lawyers to go through, certainly more work for lawyers to do before they go to court. So our rule allows you to bring a motion in an existing action or in a pending action. So you also have to include in your affidavit, if you're bringing a motion in a pending action, that we intend to start an action. And it's not really worded in undertaking language, but it's a statement that we're in court now, but we are going to commence an action. And so you have to advert to the causes of action that you have yet to draft and find pros when you're going to court saying there is a serious issue to be tried, because a facetious judge, and there are some, would say, well, where are the pleadings? Well, Your Honor, you know we don't have pleadings because this is a motion in an intended action. But the nature of the action we are going to bring is in the following areas, whether it's, wrongful interference with economic relations, which is now called the tort of unlawful means, or something else. You don't want, as some plaintiffs' lawyers will do, to say, well, it's going to be breach of fiduciary duty, it's breach of contract, it's negligence, it's one of them, not really sure what it is, because the serious issue to be tried is going to be examined through the lens of, really, is there a serious issue to be tried on that cause of action? So you don't want to, in the words of some lawyers, over egg your souffle. You want to go to court and you want to make sure that there is an identifiable cause of action if you've yet to draft a statement of claim, and a succinct affidavit that's not overstating anything, with a little bit of wiggle room that these are the facts as we've now developed them. When you start the action, then it's more likely to result in a delay in the return date of the motion to extend the injunction, because the lawyer for the respondent is concerned with defending the action, bringing a motion to set aside, or getting ready to respond to the motion to extend. In the typical case, if there is a motion to extend, it doesn't cost the defendants much, respondent/defendant, to also, we're going to bring a motion to set aside. That does allow the affiant to put in another affidavit. But the trouble with putting in more affidavits is they're likely going to be facts that have become apparent after the ex parte motion has been granted. So unless you're forced to put in a new affidavit, you would typically say, well, I will make my affiant who swore an affidavit in support of the initial ex parte motion available to be examined on a date. Those cross-examinations, once they're done, the transcripts of those cross-examinations will be put before the judge on the motion to extend, the motion to set aside. But then you've got the action. And then one might ask, what's the point of having the same witnesses go through examinations for discovery if they've been asked 1,000 questions on their respective cross-examinations? And typically what counsel will do is will say, well, we will treat the cross-examination transcripts as a proxy for the examinations for discovery, but we will allow each of our sides to ask any questions other than what's already been covered. Because you don't want to say, no, we're never going to use those transcripts again, we're going to start from scratch. Because if you've actually obtained the ex parte and got good evidence on the cross-examinations to extend it, you don't want the other side on discovery to change their story. So typically you say, we're going to use the transcripts of the cross-examination for all purposes as if they were the transcripts of examinations for discovery. Once you are into the action, then you have to concern yourself with the filing of material by the party that you've enjoined from doing something. You don't want to have a limited sealing order sealing up the material you put before the court and have that undone by the respondent filing in the public court file material that you sought to enjoin. So you have to ask the judge, if you're able to get a sealing order, to give a prospective sealing order and to make it such that any future filings will also be under seal, until such time as, there's another court order brought on notice. The whole issue, and I want to spend a bit of time on it with sealing orders, because in Ontario, up until July 2016, there wasn't a formal protocol for dealing with in-camera hearings, sealing orders, sometimes called protective orders, discretionary publication bans. Finally, Ontario caught up with the rest of Canada July 1, 2016. But on the face of that protocol, it doesn't apply to sealing orders. It applies to discretionary publication bans. So if somebody was going to court on a motion or an application or a trial and wanted to argue that the public should be excluded from the courtroom, which is a total in-camera order, or there should be a publication ban, not talking about the criminal ones that are statutory, but a discretionary publication ban. Before that protocol came in, it was sort of up to the judge to determine who, representing the media, should be given notice of this motion, which infringes upon the open court principle. And Justice Nordheimer, before he was elevated to the Court of Appeal, lamented the province for not having this protocol. And finally it came in, but somewhat ironically, the Sierra Club test for obtaining a sealing order, that was a case dealing with a confidentiality sealing order. The same test is the test to be met when you are arguing for a publication ban, an in-camera order, but the wording of the protocol on its face really doesn't deal with sealing orders. So sealing orders nowadays, with the new judges, with the commercial list or regular court judges, they are invariably saying, well, I know that protocol doesn't deal with sealing orders, but here's the way for me to make it easy to give you directions. Why don't you comply with that protocol? And the protocol is such that there's something like 100 media outlets across the country who are signed up, and they will get notice of any motion, application, where an applicant or moving party wants some level of sealing order, protective order, and most media outlets say, well, we're not interested in that commercial fight between ABC Co. and DEF Ltd. But they might be if it's a public company or there's fairly notorious parties listed on that little form. When they get notice of that, they can determine whether or not they want to participate. The theory is that the media are the eyes and ears of the public, and there's cases to the effect that you can't expect the public to go down to see what's going on in the courts, so the media are there for that purpose. The media outlets that are signed up on this protocol give a blanket undertaking in order to get that notice that they will only use the material to obtain instructions and take a position on the motion brought to exclude the public or for a discretionary publication ban. They are bound not to publicize it. They are bound not to use it for any other purpose. The lawyers for the media, invariably, when they do take a position, they will come pounding the table, talk about the open court principle, we can't have secrecy, we need to have transparency and all of that. The fact of the matter is, our Courts of Justice Act prescribes that in a proper case, documents can be sealed, either forever or for a short period of time, and the public can be excluded. Now, public excluded from a proceeding is like the most draconian, but if parties are getting sealing orders without having to necessarily comply with the protocol, then they're not going to be asking for publication bans. They don't need it. What they're really concerned about is the other side of the case, or the public aren't seeing their financial records or some other sensitive commercial information. That's another reason not to overstuff the application records with materially sensitive material, because you can't bank on the judge actually saying, oh, you're right, I too wouldn't want this out in the public, because the newer guard of judges, and unlike the old guard of commercialist judges, sealing orders used to be almost there for the asking. And nobody was required back in the day to say, well, let me take you, Your Honor, to the Sierra Club and we're going to walk through the tests. It was just like, counsel slip, is there going to be a sealing order in this case? Both sides might want a sealing order. That doesn't do it. It's up to the court to determine whether the material before the court, or part of the material before the court, should be sealed. And it becomes a bit of a nightmare when you're going through, several volumes of documents saying, okay, well, that tab should be sealed, that portion of that document should be sealed, because then at the end of the day, when you're arguing something in court, there may be other people behind you hanging around in court listening to arguments, and then you're dealing with things that might not be in the public record. So that the whole issue of protective orders, sealing orders, it's sort of caught up with the injunctive relief, particularly if you're asking the court, don't let that defendant or group of defendants do this or send something out or publicize this. The other element of, I guess, dealing with the sort of professionalism component is if you know after you've obtained an ex parte order, ex parte injunction, that there was some error in the initial affidavit. Don't wait around for a motion to set aside to be brought before you actually correct that. If I was acting for somebody responding to a motion to extend or to set aside the ex parte order, I would want to ask the affiant, this is the affidavit that you swore, and you stand by those facts. And then if the person says, well, no, I want to correct something, and when did that come to your attention? And it could be very shortly after the order was obtained, because these things are done, in a very finite period of time, and it's just, people, particularly if they are executives, who just want to sign off on, on the signature line, just send me the last page. You've got to spend the time critically going through everything and not overstating and testing with your client. And sometimes that's a hard thing to do, because clients want you to just say, take it all, wrap it up in a bow and go to court and get it. But the real concern is, and it's not in every case, as I said, if the other side is able to establish that because of an injunction, they've actually sustained damages, then you could be paying big time, like in the Yemek case. Most times you're not going to see that. If somebody says, I've sustained damages, well, what damages? Another issue that I wanted to address, just dealing with how do injunctions fit in with an action? Well, you have to, in order to get an injunction, establish that damages would be an inadequate remedy. If you then are suing for damages, and then, buried down at the bottom of page 1 in the alternative, we want injunctive relief, that it makes it a bit more difficult to say that damages are an inadequate remedy when you've been suing for damages and there's all these productions dealing with damages. One strategic bit of advice when acting for a respondent to an injunction is to spend some time saying, plaintiff or moving party, you haven't been able to establish that damages are an inadequate remedy. And I'll give you an example, a case mid-90s. Justice Nordheimer, when he was here, he gave me this case, and it was a case where we acted for a fiduciary that left the employ of an engineering firm, and there was an action that suggested that he had solicited employees away from the firm that he left, and they all joined up with him. And the statement of claim suggested that the plaintiff engineering firm would sustain irreparable harm if an injunction to enjoin this ongoing solicitation wasn't granted. And we argued that we are going to, the new company that my fellow had gone to, we will keep accurate records of all of our sales, all of our services, and if at the end of the day it turned out that the plaintiff had made out a case of solicitation, wrongful interference of economic relations, or whatever it was called at the time, they will be able to establish through our documents, because we're keeping track of our sales records and everything, the amount of damages or the amount of business that they've lost. And the late Justice O'Brien, said that that's an elegant solution, or words to that effect. And there went the injunction. But I think too little time is spent, if you're on for a respondent, thinking about ways and means of defeating the injunction. If you say, well, we're not going anywhere, we're going to keep records of everything, and if at the end of the day the other side's won, well, they'll have a measure of what they've lost. Unless the failure to grant or a refusal to grant the injunction is going to put the plaintiff out of business. In most cases, that's not the case. That is always a viable argument to make. I guess I got to watch the time because we've got 1 minute to deal with our 10 minutes of questions. And I should say, people are going to be here during the day, so if you've got questions that we don't have time to deal with right now, just corner one of us and we'd be happy to talk. But in the 1 minute that is left, does anybody have any questions? All right. Well, thank you for being so attentive. We will get the PowerPoint on our web page and mailed out to you or emailed out to you. And we also have some of the cases that are available electronically that are incorporated by reference into the PowerPoint. So that's it, and thanks for being so attentive.